All right, from one stream to the next, we are jumping right over here and getting into day 5 of the Tyler Robinson preliminary hearing into the assassination of Charlie Kirk. And we are going to go live and go, well, not go live. We are going to go back to the beginning of the hearing today, as I've been doing all week when I finish up with Daily, which affords us the opportunity to skip all the way back, you know, or skip some of the moments like lunch and some breaks and stuff like that. So on that note, I did just wrap up my stream, so I am going to get you guys started here, and let's go ahead and pull that up. And there we go. We've got this pulled up here. We don't need to chat up. I'm going to start this. I'll be watching along on my phone while I grab some lunch because it's noon here and I just got off stream. It's been a long morning so far. Here we go.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point, but here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the run time yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can.
So they're talking about the
That's why
letter
working together
for those
to
that don't
ensure
know
that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Now, I'm going to pause here for just 1 second. They're talking about the letter that flashed upon the screen. The judge was crystal clear several times that if you have a computer up and you're going to be having this evidence up on your screen, make sure you have screen protectors on so your screens are not visible. This is not the media's fault. This is and I'm pretty sure it was the prosecution. This is their fault for not having screen protectors on their screen, as the judge warned them.
Thank you. Anything further before we break? Mr. Novak.
We don't need a break.
Okay. Well,
the court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge and because what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
Okay. So they're arguing over the letter that was on one of the state prosecutors' phone computers yesterday, and again, there is an order that if it's not admitted into evidence, you cannot publish it to the media or the courtroom, the gallery. And so there was a very, very explicit order from the judge not to have, and that if you were going to have this stuff on your laptop or your computer screen, to make sure you have a screen protector, meaning if you're not directly in line with it, it's black. You can't see it. They did not have that on there. I was watching their computers the entire day yesterday looking for something. I caught that. Remember, I even on the live stream, I even went back and said, let me go back and see this. And when I realized I didn't say a word. I took a screenshot of it on my phone. So I had this the whole time. So again, this is a pretty big deal, and the reason that this is a big deal, and this is the one break that I'm actually going to kind of filibuster through. The reason this is a big deal is because, and I just got done talking with Chris Paul about this on Badlands Daily, there's a lot of Sixth Amendment questions in the entire process with Lance Twiggs, the cell phone confession, whatever, and then the letter. And as somebody in the chat asked, it's only on a phone, right? There's not a physical paper. Correct. There is no physical paper of this confession. It is entirely based on a screenshot. And the entire case is built around a screenshot. And excuse me, not the entire case. The entire confession aspect of the case is built around screenshots. And the testimony by Lance Twiggs in a deposition, a sworn deposition that he gave with limited immunity in the presence in a state capacity, right? He was talking with state officials. And they've had no right to cross-examine that. And that is a huge constitutional Sixth Amendment violation. And again, the reason I brought this up with Chris Paul today is because you have Lance Twiggs saying things like, we never talked about Charlie Kirk. We never talked about LGBTQ issues. However, or gender identity and LGBTQ policies and issues. But Robinson did talk about politics, and he talked about Trump, and he talked about votes. So, they don't get the opportunity to cross-examine and say, wait, so he never talked about Charlie Kirk? So are you aware of who Charlie Kirk was? How are you aware of Charlie Kirk? So when Tyler Robinson texted you and said, I finally had the opportunity to take out Charlie Kirk, what do you mean by finally? Is this something you guys have been talking about for a long time? Is this a big deal? Like, why is it somebody that you've never talked about politically with your romantic partner, and it's enough to weaponize you, radicalize you to go take somebody out? These are questions that genuinely need to be asked if you're going to play a deposition of the guy saying he did it. Essentially, he did it. That is a huge Sixth Amendment violation. Now, I understand this is a preliminary hearing. Also, it's a preliminary hearing to establish probable cause. And there's a reason that the proceedings are much like the same of a normal trial. Every witness brought forth gets an examination, a cross-examination, and a redirect after that. And this judge has even allowed another redirect. So, again, this is... in my opinion, this is winning over the court of public opinion, and this is publishing that letter so that everybody out there, before he gets his day in court, and this is not his day in court, this is a preliminary hearing, before he gets his day in court, this letter's already leaking around everywhere with nothing more than the context of what is in the paragraph that they showed. It doesn't even show the whole letter. And I think now you need to publish the whole letter, first and foremost. Now the damage has already been done. That cat's been out of the bag. So, again, I think this is a pretty big deal that was leaked. Again, the contents were already known, the wording itself, but now the actual letter, and there's something about seeing the letter, even though it's just a screenshot, there's something about seeing the letter that reverberates more with people than just reading something that they probably wouldn't have read anyways, right? If you see text of a confession, your average person might be like, well, you know, that is what it is. But when you see the actual letter, it personifies it, right? You can see his handwriting. It gives it emotion. And I think that's a big deal. I think that is a big deal, especially considering that, like they said, they did this before in another hearing from a while back, and they were told explicitly to have screen protectors on their computers. So we'll see what happens. Gloria Mara with a $100 rant. Thank you so much. And you said thank you so much, Brian, for all your time covering this. I'll let that go. Covering this. We appreciate this. Thank you so much for that rant. You know, I am doing this with limited ads. So this is, you know, essentially pro bono work, if you will. This is me. I mean, I'm going to do it for myself. I'm not even writing about this because it's a really controversial issue. And, you know, at the end, I'll put everything together into a writing. But as we go, and again, presenting things as they come, you know, and this is where me and Alpha, if you follow Alpha, and hopefully you are following Alpha, by the way, you know, this is where me and him got into a headbutting the other day, because when I was asking him about the bullet that was found on the computer science building, which ironically is the only building that me and Alpha both pointed to as the only other likely place where a shot could have been taken from, and that's where they find this .223 round. The day that we found out about that, I was like, hey, this is really interesting. This guy found a round and we don't know anything else about it, and I posted it on X. I texted Alpha and I clarified on the show, this is what Alpha said. This is, and I said, I still want to know more stuff about this. I want to know what officer had it. We still don't know that. What officer cleared his weapon? We don't know that. Why did he clear his weapon? We don't know that. We know the officer that found it, the agent that found it, Ben Schneider, I think, or Dan Schneider, he found it, but we don't know who cleared it. We don't know why he cleared it. We don't know the exact location of the clearing or anything else. And these are just things I would like to know. And so, again, I don't want to write as this is going, because you can be proven wrong the next day or proven different. And I don't want to, I'm just putting out facts. All right. If you look at my posts online that are clips of the hearing, I'm not really asserting too much. I think when Special Agent Hull explained the car ready aspect of why the round was cleared, I did comment on that because I didn't think that was adequate. And then the next day, his partner came in and clarified it. Kind of convenient, but whatever. It is what it is. And so that's why I'm not writing about this. So that's a long way of me saying that if you do appreciate this coverage and you want to leave a rant, it is more than appreciated, not required. What a camera angle there. What a great head of hair, dude. What a great head of hair. I'm so jealous. I am so jealous. Oh, wait, you're receding a little bit, bro. You are receding a little bit. Little bit. I am jealous, though. I wish I still had hair. That would be so cool. Shaving it is nice, but and it's refreshing. But, you know, being able to, I don't know, I'd be styling it all over the place. Yeah. I'm just kidding. I am so happy being bald. I have saved thousands of dollars on haircuts. Oh, well, we lost it. Did we? Where'd the hair go? Why did it do that? Did we go to a longer break? Yeah, we did. We just went to a longer break. Okay, now I'm going to fast forward. I forgot I have the ability to fast forward, so I don't have to sit here and filibuster. So I apologize for that. What is going on here? Do we even... Holy crap. That was a long-ass break.
Be seated. Court is back in session, noting the presence of counsel in all parties. And where we left off is the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say, preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying Motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34.
I don't think
so
he's going to block it today, but he might
I don't think
in
we
the
have the same
future.
risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
This judge has also been very fair about the streaming, so I don't think he's going to do anything against this. But the delay is a good remedy, a 30-second delay. But that means you have to catch it.
Like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here.
Notice today you can't see the monitors.
Including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as
you can't see the screens today.
We believe that the procedures that the court currently has
That's the way it
in
should
place,
be.
even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you.
I think he's going to allow the cameras for today.
Before the court issues its ruling.
No, but thank you for the opportunity.
Thank you. And I'm just updating my notes as
He looks tired.
I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
He's tired and very quiet. Let me see if I can bump the volume up there a little bit. There we go. I mean, the screen protectors, keeping the cameras out of the screens out of the camera's view, you know, was it deliberate? I don't know. That definitely can sway public opinion, as I said during that break. I mean, the chances of somebody going back and watching a 9-hour stream of this is slim to none, but that captured moment in time of something that was not supposed to be public, that's detrimental, you know? And so, again, I hate to say it, I agree with them saying this should not be streamed when they've showed twice now that they can't be trusted. I still want it to be streamed, but, you know, maybe the 30-second delay, maybe even a minute delay, and somebody monitoring it, you know, but, or just follow the damn court order and put screen protectors on your laptop like he demanded, like he ordered. Gloria, that's a great question. How will they find a jury? That is a great question. That is such a good question in a case like this. It's going to be very difficult to find an unbiased jury. All right, let's go through.
This issue rises to the level that necessitates great care.
Uh-oh.
And as my practice, I don't like to rush or make snap decisions, and I want to give this the full analysis that it's due. So thank you again for your patience. Transparency. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you.
Wow.
Turning to the defense, if you wish, you may call your next witness.
As the ATF DNA expert for the defense is testifying,
Yes,
we can
Mr.
no longer
Miranda,
see the
and
exhibits.
I'll allow all
Wow.
parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my we have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander?
This is so crazy. Now, this thing is getting nuts.
To the defense?
An objection to the defense presenting their case because it's a DNA analyst for the ATF?
I'm not sure what was being requested by Mr. Grunander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. No, Your Honor. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Ms. Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
Here we go. We can't see it. We can't see it. This is crap, man. We've gone the whole time. And now the last person. This is nuts. This is nuts. And to be fair, it's the defense that requested this. So, I don't want to say, it's not like I'm biasing Robinson here. His counsel's the one that requested this. We're missing, wow. This is crazy. And then the state motion to just end the case right there, not even let them call this witness. We're not allowed to hear this, guys. Man. Yeah, Glorious is bad timing on request versus ruling. To be fair, the request was made, the objection was made, I think it was this morning when it was discovered that that leaked photo had gotten out. By the way, while we have a break here, McLokey, thank you for the $5 rant. Greatly appreciated. McLokey ranted, appreciate all your hard work. Thank you so much. I hope you guys get something out of this, right? This is key here. Seeing the process, understanding the process. I've sat in the courtroom many, many times for criminal trials and civil trials alike. Likely be sitting through another one if Ash has to go to trial again, because I will be flying out to Colorado to watch that again and watch her kick ass again. Yeah. So this is fun to me, man. I'd rather listen to it than read transcripts, because listening to it, you hear the emotion, you hear a lot of context that you lose in transcripts, which is why I think all federal cases, it should be mandatory that they're live streamed. I think that's crap that we can see state level and lower cases live streamed, but not federal cases. We don't want to see how that sausage is made. It's absolute crap. Absolute crap. So I'm going to fast forward until we get some volume.
State read, for instance, the next sample down 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing.
Great. So we just missed that whole thing and we were allowed to hear it.
That you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors at counsel table and podium. Any clarification on that?
Well, that's why I give my notation at the beginning of the morning that the parties are responsible to monitor their monitors, and that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. We cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right. The order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
What a shit show.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing, and the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Thank you. Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay. Let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained, and then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1?
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're...
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify it, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, well, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap, and they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
Right? And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it, your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes. Once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you, say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
again, not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
no, you were right, 154. Yeah, this is one. What's the exhibit on this?
This is 154.
Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele.
Correct.
At that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that?
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So It's possible for DNA evidence to, we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out, so it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
I noticed throughout your report you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately In all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying it's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
one exhibit, Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, and trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, I will probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7. with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of two individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample that that was a sample consistent with at least 4 contributors, correct?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused.
Yes.
All right. Thank you, ma'am. You may step down. Anything further from defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling?
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Mr. Visser.
That would have been epic.
In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Your Honor, Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
Well, did the media...
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
No! Such shit.
All right. Nothing further from any of the parties? Okay. Just
Come on, media attorneys, go to bat for us here. Come on. You ruled we could see it. Before you ruled we couldn't see exhibits.
The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative.
This is crap.
The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay.
That's such horse shit, man.
All right. And as it's switched to audio only, to the state, now am I understanding there's no audio on this surveillance on 12.1? Is that correct? All right.
No, this is the enhanced, zoomed in footage of him taking the shot or getting on the roof.
And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1.
This is so lame. So 12.1, I believe, is the zoomed-in footage of him on campus.
Just let me know. If you're ready, let's go ahead and play it now.
This is so lame. Oh, you guys can have audio now. Oh, but during the DNA analyst testimony, we couldn't have audio, even though we were supposed to be allowed to have audio. So the media is the one getting screwed in this. The media is absolutely the one getting screwed in this. We can't see 12.1, which has already been broadcast, zoomed out. Then they played the enhanced version just for the judge. We weren't allowed to see that. Now they made a motion to allow us to see that, and they said, okay, you can see that. And then this morning they're like, you can't see any more exhibits, and apparently that can apply retroactively to a previous order the judge had made. What a crock of shit. Ugh. I can't remember who it was that predicted Tyler Robinson would testify, but that would have been epic if he did. If it goes to trial, I think you might see him testify at the very end, depending on how the case goes. But that would be pretty epic to get his side of the story. But then he opens himself up to a whole bunch of questions and Fifth Amendment rights and everything, so yeah, he's not going to testify. That would be cool if he did, though. Like when Kyle Rittenhouse did it. That was ballsy, and it worked out for him. Wait, hold on. Did Kyle Rittenhouse testify? Yeah, he did, right? Hold on. I thought he did, right? I live streamed that one, but yeah, he did testify. Yeah. I couldn't remember. I was like drawing. It was Tina Peters that we speculated would testify and then decided not to testify. That's who I was thinking of. All right, so again, we are sitting here listening to testimony or listening to audio-less testimony that we were ruled we could see, and then because it's this morning's ruling, we were ruled we could not see it. And once again, to be clear, this is the defense's fault. Not that, it's necessarily bad for them, but the defense was the one who brought that motion. And so while I'm mad, and while I think it's an injustice to the defense that it only occurred on their last witness and then on this 12.1 exhibit, it ultimately was their own doing. Now, again, this is kind of a smack at the state prosecution who leaked the photo, maybe inadvertently, maybe advertently. But either way, the image of his text is now out there. I've already seen some people drawing comparisons to the text and a document that has Lance Twiggs' writing on it, and I don't think they look the same, other than the fact that they write like chicken scratch, but the lettering themselves, like a handwriting analysis, I don't think would conclude that, based on that, the letter was written by Lance Twiggs. That being said, should be able to get some writing from Tyler Robinson to do a handwriting analysis to see if it matches his. Also, the fact that you don't have the physical letter should make it inadmissible, in my opinion. That letter should be inadmissible if all you have is a photograph of it. So I'll just throw that out there. State leaked a photo. Yes, they did. The state leaked the photo of the quote-unquote confession letter that was under the keyboard. That was also a really weird section of the text messages. Let me see if I can find those real quick. I think Andrew Colvett has a post with those in him. So let me see if I can find them. I hate using him as a source because I think that guy is one of the grimiest people on planet Earth. But let me see if I could find it. Yeah, here it is. That's not it. Okay, so that's not the text that I'm looking for. Okay, so, all right, here is the text that I think is very questionable, and this is, again, this is why you would need cross-examination. So, on Wednesday at 11 p.m., Wednesday at 4:30, Tyler texts, "I love you, moi. I love you more, moi, moi, moi." Then 6.5 hours later at 11 p.m., he texts, "Drop what you're doing, look under my keyboard." And you don't have timestamps, so you don't know how long before the response. But Twiggs writes back, "What?" with all these question marks. "You're joking, right?" And then he writes, "Fuck, I tried to delete that." And I don't know what he tried to delete. But how long was the response there? You know, like, did he actually go and look under the keyboard and read it and then respond? Or did he just respond on emotion? Again, this is why we need the timestamps on those text messages, so we can see the sequence of how all of that played out. You know what I mean? Because, like, if he just said, like, "Look under my keyboard, fuck," whatever, and he's like, "What? What prompted you?" Like, if my wife texts me and is like, if I text my wife and I'm like, "Hey, go look under my keyboard, I need you to take that, whatever," she'd be like, "Okay," and she'll come back and be like, "What is this?" But it'd probably be like 5-10 minutes later. I don't know. So I just want to see the timestamps on that, how long it took him to actually respond to that text message. You know what I mean? I hope that makes sense. Are we sure Twiggs didn't have both phones? I don't think he had both phones, but my only question, and again, this will come out in trial if there is a trial, would be, was his phone cloned? Because we do have that bizarre incident where Miss Nobles testified that there were gave a statement that there were 3 people in Robinson's car, in addition to a bald man that was driving it. And that was at the same time that Hull said that Tyler Robinson's phone was pinged in that area. So did somebody clone his phone and send the text messages from that car full of 3 people, none of which, or 4 people, none of which are alleged to be Tyler Robinson, with a bald man driving? Because Tyler Robinson clearly is not bald. In fact, he's wearing a hat most of the time. So being able to discern that he's bald would be quite an accomplishment. So again, I'm sure if there is a trial, Miss Nobles will be testifying to that point. So that is interesting. And again, that's why I think this is still a preliminary hearing and you can't go into all that kind of stuff. And I know that sounds crazy, but you know, if you are still on the, and I'm 50-50. No, I'm probably like 30-70. 70 he did it, 30% he didn't. And the 30 is because there's a lot of things that still I can't justify, and I still can't put him on the roof definitively. And so that's probably the discrepancy there. So in a trial, when all of that stuff is unpacked, if they go in and they're like, oh yeah, the metadata definitely proves it was him, then that's when you go full bore. But people are talking about JFK, RFK, MLK, and all those assassinations in the 60s, and you're looking at those and you're like, well, you believe that those were all conspiracies and that they were whatevers. Hey, what happened here? What are we doing? What are we doing? Oh, okay. I can skip through this. Sorry, guys. I'm sitting here talking and.
Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right. All right, so there we have it. September 1st, we'll get closing arguments. Is that what he said? September 1st? It's adjourned until then?
All right. All right. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total.
Okay, so September 1st. So we've got, wow, almost like 3 weeks for everybody to stew on this. Very interesting.
For argument, that's encompassing.
All right. So there we have it. That is over for the day. And for the next 3 weeks, it looks like. Let me pull out my calendar here. My handy dandy calendar. And September 1st is a Saturday? No, oh, wow. That's like over. I forgot. It's only July. That's a Tuesday. So September 1st is a Tuesday. Man, that is a long adjournment. Adjournment. Man, holy crap. All right, stand by 1 second. I'm trying to get my timer thingy here. Okay. Why won't it go away? All right. What? Well,
detail / smudging.
Hold on. I'm trying to get this to disappear. Okay, there we go. Got it disappeared now. All right, so that is the end of the preliminary hearing until we get some closing remarks at September 1st. And let's see. Let's go ahead real quick before I give my final thoughts on everything and hit a sponsor here. And There we go, guys. We hear a lot about crypto, but here's the part that most people miss. Crypto was created so you could actually own and control your money. After the 2008 financial crisis, Bitcoin was designed as an alternative to banks. So instead of a bank holding your money, delaying transfers, or limiting access, you are in control. And if you've ever had to wait for a transfer to clear, you felt that problem. Now, fast forward to today, and everyone's heard of crypto, but getting started still feels kind of complicated. That's exactly why I use Rumble Wallet. It takes all the complexity and makes it simple. Choose what you want: Bitcoin, dollar-backed stablecoins, or even digital gold backed by real gold. There's no complicated setup. It connects with MoonPay, so you can use your credit card, debit card, or bank and be up and running in just minutes. Once you're set up, you can even support your favorite Rumble creators like us direct, or like me directly. So now do this. Scan the QR code, or you can click the link in the description and download Rumble Wallet. From there, you can set up your wallet, tap buy, and boom, you're in the game. In just a few minutes, you can go from hearing about crypto to actually owning some. All right. Thank you to Rumble Wallet for that sponsorship. And yeah, I mean, I think this was a not a good hearing for Tyler Robinson. And the reason for that, I've told you guys, is the testimony from Twiggs was damning. However, I also believe it was unfair. In that they were not able to cross-examine him. I've seen, I've made these posts online and said as much online. And, people are saying, well, this is a preliminary trial. He doesn't have that afforded to him. Yes, he does. He absolutely does. That's why every single witness that we've seen has been cross-examined, cross-examined, a redirect. And this judge is, and I don't know if this is Utah's procedure, but he's allowed a redirect. So you've been able to, even after the redirect, which typically is the end, they've been allowed to come up and redirect. So in other words, it's like a perpetual process, a never-ending process where the opposing counsel can come up and ask more questions, and it just keeps going and going and going. And so, Gloria Mara says, who can believe a furry? What do we know about this whole furry story, right? The only thing we know about the furry story is that picture of him in a onesie pulled over his head, and everybody's like, he's a furry. Well, I mean, the furries that we have come accustomed to, they go full on, like masks, covering their face with dog masks or whatever furry they're an animal of, wearing full cover masks. This is just a onesie. And again, I'm not defending whether or not he's a furry or not. I don't know. There could be more evidence that he is. But I mean, that would be like my wife has a Pikachu onesie. She has a Chewbacca onesie. She has a shark onesie that I bought her for Christmas because she loves sharks. Like that would be like me taking a picture of my wife in a shark onesie and calling her a furry because she likes to wear that onesie. Now, is it kind of gay for a guy to be wearing a onesie? Yeah, but he's literally gay. So, who knows? Even the trans thing. I mean, there's nothing. He wasn't asked anything about being trans. I did think it was interesting that him and Tyler talk about politics, but they never talked about Charlie Kirk, and they never talk about LGBTQ issues. They only talk about Trump and votes that apparently are going down, which is kind of crazy. That you go from, first of all, an early 20s gay couple with allegations of transgenderism and furries, and they're not talking about those things, but then you're radicalized enough that you go and kill somebody because of those ideologies. That is a little bit bizarre to me. But again, maybe we're going to see more come out in the trial with the Discord chats and all that stuff. We were forbidden from seeing that stuff. So just kind of odd to be radicalized so much in such a short period of time. Now, again, this is why the cross-examination is very important, because you can then prod that statement that you guys never talked about Charlie Kirk. Well, how did you know about Charlie Kirk then, right? Was Lance Twiggs, how was he familiar with Charlie Kirk? How was Tyler Robinson familiar with Charlie Kirk? Have they watched his content before? How many hours of their content have they watched before? These are all questions that would have been asked. You never talked about LGBTQ issues. What specifically about Trump's policies have you talked about, right? Because if you're not talking about LGBTQ issues, which have been not just the forefront in conservative America, but also in LGBT America. These have been forefront topics. And you have somebody that went so far as to commit a capital crime because of those, allegedly because of those issues, and they never discussed it. That's very, very odd. And this is why I feel like the Sixth Amendment rights were infringed upon by not allowing the cross-examination. Is Lance Twiggs involved in this? I don't know. To be honest, my personal opinion, there's a lot more to Twiggs' involvement in this than we know. And, you know, even like I mentioned on Daily today, even when they were asking Twiggs, what did he do? Like after he had got back to the apartment, so September 12th or 11th or whatever, you know, he asked Twiggs, what did he do after he told you all this? They redacted like 30 seconds and then said, and then he comes back and he's saying, and then he went to go see his mom to turn himself in. What was going on in that 30 seconds that they had to redact that? You know, I mean, who knows? It could have been anything, to be honest with you. Could have been, you know, oh, he wanted to, well, I'm not even going to go there. He wanted to have some furry time. I don't know. There was also the moment where he was in front of the stairs on surveillance footage from the campus that they cut a minute and 16 seconds out. You can't do that. You can't selectively edit that footage. I don't even know if they caught that, the defense. Now, hopefully they did, but they didn't bring it up. So you've got that. That's another key moment that's missing. You know, they testified during the trial that they had no footage of the shot actually being fired from that corner of the rooftop. Well, how do you not have footage of the shot being fired when you have footage of him going into the prone? Did that camera all of a sudden cut off at the moment where he took the shot and then came back on as he's running across the rooftop? That's very odd that you don't have that footage. So, you know, again, these are just questions that need to be asked. The minute and 16 that's missing, it appears that Tyler Robinson's manipulating his phone. He's holding his phone in his hand and doing something on his phone. Did he get a phone call? And if so, who was that phone call? Who did he talk to with Turning Point USA when he went down to where Charlie was speaking from? Who did he speak with? They said he engaged with somebody from Turning Point USA. There's a lot of questions. But again, for a probable cause hearing, this is the one spot where I would absolutely agree with Alpha. I think it does rise to probable cause. And there will be a trial, or there will be a plea. And I was talking with Alpha last night before sit rep. We were talking on the phone, and you know, he had said, and I don't know Utah law, I don't know, but typically you don't get plea deals after the preliminary hearing. Like that's your last chances before the preliminary hearing. Once it gets to that point, you keep going. But you know, Alpha did bring up a great point that perhaps they're going to take the death penalty off the table. Erica Kirk will come out and say, it's against my beliefs. I've already forgiven him. It's against my beliefs for the death penalty. And I agree with this fully. This is also my thought process in a possibility of how this plays out. She comes out and says, I've already forgiven him. It's against my religion for the death penalty. And so I'm okay with this plea deal. Both parties accept. And he pleads out and serves life in prison without parole. Could be. Or they've still got aces up their sleeves. I don't know if they did have, you know, proverbial aces up their in the hole, aces up their sleeve. Why didn't they unleash that here? I don't know. Could have been because they knew they weren't going to get Twiggs on the stand, and so the confession would automatically, you know, give that probable cause, and so they're saving it. That could be. There's a lot of stuff we don't know. I will say, in my opinion, they did not prod nearly enough into some of the things like the metadata on the phone, you know, the metadata on the letter, the Noble situation I talked about. There's a lot of concerns for me here. So that being said, closing arguments September 1st, or their closing briefs are due by September 1st. They'll have a 4-hour argument. It is not going to be simultaneous, which is kind of weird. I didn't know that they could do that. It'll go state, defense, and then the state will get a chance to rebut. So it'll probably go an hour. If I had to guess, it would be an hour to an hour and a half for the state to give their closing arguments, an hour and a half for the defense, although maybe an hour and a half, 2 hours for the defense to rebut it and give their closing arguments, and then usually like half an hour for the state to give their final rebuttal to the closing arguments. And so that will be on September 1st. Until then, we won't know much. And there we go. Yeah. Boldham, I know what you mean. I should have clarified. Simultaneous. He had said simultaneous arguments, and then he changed it. You're correct. He changed it to simultaneous briefs, meaning that the state will brief first, and then but they're going to be giving arguments though on September 1st. So a little different there. So yeah, we will definitely cover that on September 1st. We will be. It starts at noon, so I'll be coming off at Daily, and I'll go right into it, and that will be the last we hear until the trial, if there is a trial. Maybe there's a plea deal before September 1st. I could see that too. Take the death penalty off the table, and I personally, I think that would be tragic if there is a plea. But again, it's up to Tyler Robinson and his counsel. And again, something that everybody always misconstrues. Just because you have doubts about whether or not Tyler did it doesn't disparage or take away anything from the assassination of Charlie Kirk. You're just speculating that it wasn't Tyler Robinson that murdered him. That doesn't take away from wanting justice for Charlie's assassination. That's just calling into question the narrative that's being put out there and whether or not it's actually true. And there should absolutely be scrutiny on all these things. If that's why we have a presumption of innocence in this country. It is one of the foundational concepts of our justice system, is the presumption of innocence. And we should always afford that to people. We should also afford all the rights that are outlined in the Bill of Rights to them. And the Sixth Amendment is a very important one. And again, I think that was one of the bigger injustices in this. We haven't even mentioned the ATF medical examiner. Like, where was the medical examiner testifying on this? I'm half tempted to go out there with my 30-06 and get a couple boxes of core locked and find an open field and just start shooting pieces of plywood with ballistic gel behind it and trying to duplicate a 30-06 soft lock, a core locked soft tip ammo, doing what they say it did, because it won't do that. I'm telling you, it won't do that. A human neck is too thin for that, and there's not enough. Even if we know it didn't hit his esophagus, which is still, that's just cartilage, right? It's not bone. And so, given what we saw, because we all watched it live, it's still, it would be, I mean, it would make JFK's miracle bullet, magic bullet. It would make JFK's magic bullet look like the norm. And I don't buy into that. That's all. That's it. So on that note, I'm actually gonna reach out to Alpha and see if maybe we can do our wrap-up hearing, our wrap-up stream, him and I, today, and talk this out. And yeah, maybe we'll get that done. So let me pull this up here, and we did have a few Rumble rants and other things come in, and I want to give thanks to those people. Gloria Mara, we read both of these during the stream. Gloria Mara says, thanks so much, Brian, for all your time covering this. We appreciate you, with a $100 rant. Thank you so much. God bless. McLokey, $5 rant. Appreciate all your hard work. Thank you so much, McLokey. Appreciate that. Marsha gifting a sub that went to Prioritize. I saw Prioritize with his comments in the chat about I would never do that. No, I can't give away subscriptions. I mean, this is what I do for a living. Not just this, but writing and politics and news and all that stuff. And so, yeah, I just can't give them away for nothing. But I appreciate Marsha donating one. I definitely appreciate that. You guys are awesome. Be sure, if I don't do the stream with Alpha, and I can't guarantee that he'll want to do it today, he has agreed that we'll get it done at some point. But if we aren't able to do it today, we'll get it done soon. I've got a lot of work. I've pretty much taken this week off to cover this, so I've got a lot of writing and other stuff to do as well. Tune in tonight. If you're not following me, if you guys are over on YouTube, follow me over on Rumble. Every Friday night, my wife and I do a date night podcast. It's a lot of fun. We just hang out, watch 80s music videos, and play couples games. It's kind of interesting. Last week, we had Cam and Jackie over for the 4th of July, and they participated with us, and we played the Newlywed Game, and that was a lot of fun. Maybe we might even continue the Newlywed Game, just Christy and I. That was a lot of fun. And maybe go a little more into explanations and all that. Prioritize, I know you were joking, man. I'm just kidding around. Well, I'm explaining, but I'm also kidding around. I know you didn't actually take offense to that, so there we go. Independent Many, so good to see you. One of the OGs, man, from back in the day. I actually was talking with Eli this morning about jumping on a Stuck podcast to talk about this. I would have the other night, but they didn't tell me until it was too late, and I had plans with the wife already, so I've been neglecting my family. Well, I've been neglecting her over the last week because of these streams. They go till like 7 o'clock at night, my time, and then I usually have another show like right after that. So, Huck Fillery, what if the neck wound was an exit, not an entry wound? I mean, you would have an entry wound somewhere then, if that were the case. So there's that. Crimson Veritas, another one. Good to see you. Another OG. Got a lot of OGs in the chats, though. You guys, we've got a very good crowd here. I'll tell you right now, the one of the theories that I still can't rule out is the plate theory that me and Alpha came up with on day one, like right away, immediately. I can't get away from that one. I can't get away from that one. And that one would make sense. And you would say, well, the plate theory is kind of gone because they got the fragment of the round, you know, that has the butt of the bullet that showed the diameter. The second that the ATF lab says we were supposed to get 7 fragments and we only got 4, that should be inadmissible, because the chain of custody has now been broken on those rounds, and you don't know if the 4 are still the originals. And a lot of this, like, I think it was yesterday, I alluded to President Trump on Air Force One when he had the other Air Force One, the new one, go to Mildenhall Air Force Base, and he flew on the old Air Force One. And I brought up the TV show Scandal, right? And in Scandal, I kid you not, guys, if you haven't watched the TV show Scandal, it's like a player's guide for deep state conspiracies. And it was made back, I think, in like 2013 or something. It's an older show. It went 7 seasons. There's a scene in there where the new president-elect gets assassinated, and they run it as a patsy that was in the crowd that shot him, but in reality, it was somebody in the floor under the stage that shot him from the ground up, right? I'm not kidding. Like, this is a legit show that has led to theories around Charlie Kirk's assassination. I'm not saying I believe these theories, but there was a guy in the ground under the stage that shot up and shot the president and killed him. And the patsy was a guy in the crowd that shot him with a high caliber rifle. And part of the cover-up was somebody getting access to the body at the medical examiner's office and switching out the bullets. And so when you see, and again, I know this is TV, but granted how deep this television show went, I mean, the whole TV show was the deep state versus a president and a law firm that is adjacent to the president. the president was having an affair with the person that runs that law firm. And so, you know, when you see so many of these, quote unquote, and it deals with election fraud, voting machines switching votes, and the president was only there because of an illegitimate election, like so many conspiracies that we've seen unfold over the last, 10 years. And it was all predicted on TV. And DJ says people get a lot of ideas from TV. Yes. Also, the intelligence agency has a lot to do with TV, in my opinion. Somebody else said something in the chat I wanted to find real quick. Hold on. Where'd it go? It was about the bullets, and I want to correct the record on that. Max Love and Glory said, I think it was 5 fragments. I noted they referred to page 14 of the ATF exhibit. I actually went back and played this testimony on Badlands Daily. It was 4 fragments that they were given, and it was reported, and it was photographed that there were 7 fragments. So I can tell you that as far as what was on the record in the trial, in the hearing, excuse me, not the trial, in the hearing, it was 4 fragments that were given to ATF. It was supposed to be 7. And I can say that with absolute certainty. Max Love and Glory, I'm so glad to be reminded of Scandal. I watched many seasons and must go back and see end of series. It was one of, it was Olivia Pope. Yeah, Olivia Pope. She's going to play Michelle Obama one day. Watch. Because she's got kind of like the same like mouth as Michelle Obama, but she's infinitely prettier than Michelle Obama. But they'll use her to play Michelle Obama. Mark my words. Olivia Pope, though, it was a great series, man. What else we got? Grace Good, I don't want to believe any of the conspiracies on Charlie. It's too hard as it is to have him gone. I agree. But it's an injustice to Charlie not to prod every single possibility, right? It's an injustice. And, if we have a trial and we get to unpack all this stuff and we find out the metadata, we find out, all of the things, we were talking yesterday, me and Alpha, about the GPS on his car. And if they're able to track that stuff and put him there definitively, then so be it. Tyler Robinson needs to rot in prison and rot in hell. But it's an injustice to Charlie if Tyler Robinson did not kill him and it's not thoroughly prodded. And again, if this was just your average Joe out on the street, I would say, yeah, like if this was just a guy that was at the event and they killed him and it was just a random shooting, maybe a personal beef, but just a random shooting, then I would say, yeah, this is no big deal. But Charlie Kirk, there was a lot of things that are important to explore with Charlie Kirk and his business, his influence, certain entities that were not too pleased with him and so forth and so on. So, yeah. No, Olivia Pope is definitely not a man. She is a very, very attractive woman. But like I said, she just has some features that reminded me from time to time of Mohap. So I'll leave that there. What else? All right. I think that'll be it. And like I said, if we can do the stream, we'll do it. If not, we won't. But I do want to thank you guys all so much for tuning in. Hit that thumbs up if you can. Share out. Follow me on all my platforms at CannCon on X, at CannCon on Truth. If you're on YouTube, jump over to Rumble. Give me a follow there. If you're on Rumble, jump over to YouTube. Give me a follow there. It helps me out tremendously with getting more eyeballs on the content here. I will be doing my Week in Review podcast tomorrow morning at 10 a.m., so be sure to check that out as well. And that'll be it, guys. Thank you all so much for tuning in, spending the last 4 or 5 days with me on this. And I look forward to justice, one way or the other. Objectively, one way or the other, justice for Charlie. God bless. Stay frosty. God bless each and every one of you. God bless America. Make the deep state motherfuckers play for this.
Open your eyes to a new world, which never knew existed.